Put your questions in the comments now so that I can answer your questions. I have a good topic for you today. I'm going to continue the topic about getting the work permit. So go ahead in the meantime while I'm talking. Put your questions in the comments. So I am on multiple platforms here today because I want to spread this information, especially now when there's a lot going on in immigration. So put your questions in the comments. I am on TikTok, I'm on Facebook, YouTube, Twitch, and I'm on Instagram. I am looking at all of the comments that are coming in. So don't hesitate to put your questions in the comments because I will see those questions coming in and I will answer it. But let's talk about how do you get the work permit? Now, there are multiple ways that you're able to do that. There are multiple ways to get the work permit. Now, one of those, I'm going to go over different categories. One thing I do want to make clear is that you cannot get a work permit just by being here in the US. It's not that simple. If it was, can you imagine everybody that was coming in with a visa would then get a work permit? So you have to qualify, and there are multiple ways that you're able to qualify for this. And so I'm going to go over some of the ways that I help my clients to get status, especially if they're in a situation where you're here already. You may have already overstayed your visa and you're trying to figure out how you can fix that. That is one of the areas that I focus on in my practice. And we've been very successful with helping certain clients to get their status back in order so that they are able to thrive here in the US and make a life. Now, the work permit is different from the work visa, right? So the work visa, you're outside of the US, you cannot you cannot independently submit a work permit application because you want to work for a certain employer. You have to go through the employer. If you want to come here to the US to work from outside of the US, you will need to have the employer file for, in most cases, the employer has to file the petition for you to be able to get your visa to come here into the United States. Now, if you're already here and you're trying to figure out how to get the work permit, you're going to have to qualify for either a form of relief, or you're going to have to qualify through family, through employment, or, and when I say relief, I mean humanitarian means. So, for instance, if you don't have your status here, maybe you came into the country to seek a better life, but when you got here, you found that things were harder to, it was harder for you to obtain status here. That is where we can look at whether, what have you been through, and depending on what you've been through, you may qualify for relief to get the work permit here in the US and to regain your status. So let's talk about employment first. Now, if you're going to apply for a work permit here in the US through employment, either in the case where you're going for a visa or a specific status, that's the employer that has to do that. Now, if you are looking at getting a work permit for yourself and the employer is sponsoring you for a green card, that's one way. Now, the thing with employment based is that you cannot overstay. And then, so if an employer is promising that if you overstay, and continue to work for them, they'll eventually get around to sponsoring you for the green card. But you have to work for them first, then they'll get the green card. That is not true, right? It's either the employer is just trying to get you to work for them, or the employer does not know the law and they're trying to let you do something that you cannot legally do under immigration law. The employer, once you've overstayed your visa or once you've started working for them, before you've gotten the visa or the status, it's going to be denied, right? That's not allowed. So the employer, if it's an employer, the employer, you can't start working for the employer first. The employer has to do all that they have to do. Submit the labor certification, submit the documentation, the petition to the USCIS, and then once that's complete, you can file for the adjustment of status when they're filing for the petition. The adjustment of status application is what's going to get you the work permit. Once you get that work permit, you're able to start working on that work permit while you wait for the green card to be approved. So that's based on the employment. But say you're in a situation where you don't have an employer. How do you go? What do you do to get a work permit? Now we'll look at whether you can do this through family. Do you have a U.S. citizen or legal permanent resident, spouse, a parent, or a citizen adult child who's age 21 or over? If you do qualify through these family members to file for an adjustment of status to get your permanent residence, while you're going through the adjustment of status process, you are going to get the work permit. By the way, one of the good pieces of news that we got earlier this month is that they're now issuing 5-year work permits. 5-year work permits. So that is excellent here. 5-year work permits means you don't, while we're waiting for sometimes the lengthy process to be completed, you don't need to renew. And your process should be done in less than 5 years, but they make it 5 years. So neither immigration nor you as an immigrant have to deal with the stresses of renewing and being out of a job or being out of work because now you have to renew. So now, once you have a qualifying family member who can petition for you, then at that point, once you filed your adjustment of status application to get your permanent residence here in the US, you're going to also obtain the work permit, the 5-year work permit, while you're going through the process. Now, let's talk about you don't have family, you don't have an employer. Let's talk about the other options that I look at. Now, say you don't have family because you don't have a family member available. Say you have a family, but say that family member, they could sponsor you, but they instead they're mistreating you. So if you have a spouse, a legal permanent resident or citizen spouse, a parent, if you're under 21, under 25 in some cases, or a citizen son or daughter who's age 21 or older and they are mistreating you, you could qualify for your own work permit through VAWA. And you could get your own green card. That means you don't involve those relatives. You don't involve them in the process. It's completely confidential. So a lot of people think that, oh my gosh, my family member cannot, they will not apply for me, so I can't move forward. Not true. This is where, if you're being mistreated, schedule an appointment. Let's talk about your situation and determine whether you qualify. This is called VAWA, where you have a U.S. citizen or legal permanent resident, spouse, parent, or child who is mistreating you. Now, let's talk about other options. These options are options that not a lot of attorneys screen for. I think this is why I screen for this. And when I say screen for it, I check everything in the consultation to see if there's any way for you to qualify, especially when you're in a situation where you don't have your papers, you don't have an employer, you don't have family members available. What is available to you? And there are other forms of relief that is not commonly talked about, but which have been game changers for my clients. It has changed the lives of my clients. And this is, for example, the T status. So the T status is for victims of trafficking. But what a lot of people, and I think this is where even attorneys don't screen for it, is there's a misconception about what trafficking is. Under immigration law, it is broadly defined, but trafficking is I like to say it in summary this way because it applies to different situations. But if you are being forced, you're in a situation, you're in a relationship, you're in an employment situation, you're maybe living with someone who offered you their place to stay, and then they start to force you to do things that you don't want to do. They force you to do work for them. They force you to do tasks for them. They force you to do any kinds of acts for them that you really didn't want to do, but now they have this power over you that they're using against you. This is considered trafficking under immigration law, and it entitles you to status, the T status. And this is because many people are lured into the United States. And even if you're not, if you weren't convinced to come into the US, but you've been here for years and then you ended up in a situation like that, that still applies to you. And it is there for you, whether you've worked without a permit, whether you've been out of status. And yes, even if you've crossed the border without permission, these options are available for you. And they've changed my clients' lives. And this is why I'm so passionate about spreading the word about this, because you would be surprised when I go through these consultations with my with individuals. You'd be so surprised how many people have to go through hell while they're here, especially without their papers, and it turns out that they have been the victim of trafficking. So that's definitely one of the possibilities here. Now, T status allows you to bring your status back up to date. You will then have your new updated I-94, and you'll have status for 4 years. Now, you can also apply for permanent residence after you've been approved for T status. So it not only just offers you a temporary status, but then you can become a permanent resident, a path to permanent residence, and then eventually citizenship. So this is where it really has been a life changer for my clients that have been here, and they thought they didn't have any options, but it turned out they did. Now, the other options would be the U visa. So the U visa takes a long time, but they've implemented a new policy and a new program where they'll evaluate whether you have submitted a proper U visa application. And if you have, they'll put you in deferred action and provide you a work permit and, social security number to wait while you are going through the U visa application process. Now, the U visa is for victims of crime, certain qualifying crimes like assault, robbery, stalking, domestic violence. Those are examples. But say yours never fell within the list that I gave you, keep in mind that this list is not exclusive, meaning if you were subjected to a crime that resulted in your mental or physical abuse, then you could potentially qualify for the youth status. The youth status does take a while, and under the U status, the law enforcement certification is required. We represent our clients and we work through the certification aspect of it. We don't let our clients do any of that. We work on their behalf to get that done. And then finally is asylum. Asylum is a way to apply. Now, you have to make sure you apply for asylum one at least within 365 days after your entry. Even if you've already overstayed your visa but you're still within the 365 days, make sure you look at asylum. If you're afraid to go back to your country because you're being targeted, you're being threatened based on your identity, based on maybe the group you identify with, is your family on a whole being threatened? Are you being threatened by gang violence? Are you being threatened? Are you, for example, being threatened because you're not complying with maybe a religious norm in your country or a cultural norm in your country, and so you're being targeted? Do you hold a political opinion that is causing you to be threatened? Are you involved politically? Do you, when you express your opinion, your political opinions, are you being threatened? Do you belong to a religion that is potentially being targeted, causing you to be targeted? If so, then you could qualify here for relief through asylum. Now, with asylum, you are able to get your work permit when you get your work permit, that will be also a 5-year work permit. Now, the process does take a while. Most processes, we hear about the um, uncommon scenarios where the asylum took less than a year. But for the most asylum cases are taking years, even up to 5 years. So this is a reason why they're issuing 5-year work permits. Now, 150 days after you've properly submitted your application, you can apply for the work permit. And we represent our clients through the entire process to be able to get walk them through the process, including getting their work permits. So as you can see, as I have listed these different forms of relief and benefits, as you can see, the work permit is kind of like a benefit that you get if you qualify for something else. But while you're waiting for that something else to come through, you can get the work permit. And as I said before, it's beneficial because now they're making it a 5-year work permit. Now, one other thing that's the parole. If you've been paroled into the country and they have the USCIS, they are issuing all sorts of. They're doing a campaign right now to try to remind those who have been paroled into the country that before the parole expires, they can apply for the work permit. So this is usually for people who have come across the border. So if you've been watching the news or keeping up with the news, you'll know that that is something that's happening right now. And some people have been paroled, just depending on the reason they're coming into the country. And if you have been paroled, then you can get the work permit. You can apply for it, but you have to apply for it before it expires. All right. Thanks so much for your patience as I got through what the information I wanted to share with you. Now I'm going to scroll through and answer your questions. So now is the time to put your questions in the comments. I'm going to go very quickly and just answer each question. Good morning, child of God. It's nice to see you. All right. So, please, what can a person do if they were not sent an interview day but got denied that they didn't show up to the interview? So, there are different ways that you could possibly approach this. Sometimes it may be as easy as contacting them to let them know what the issue was, and then they may reopen your case as a result of that. Some in other cases, you may have to reapply. In the case that you have missed your interview, you can appeal it, right? You would be able to appeal it or go through an administrative motion to reopen if it hasn't been a long time since you've gotten the denial. But if all else fails, you probably would have to reapply, unfortunately. You have to make sure you document that they had the wrong address, that they issued it to the wrong address. Contact them and verify where was this notice sent, and then make sure that you can contact them. But this is where representation is going to be very important, because the attorney is able to contact the USCIS directly and possibly just get it reopened. All right. Okay, so is it the same for the R visa usually how long does the enforcement process take? So I'm not sure what is the same for the R visa. Can you just elaborate on that? Um, is it only some employers that can file for? So, it's going to depend. Not some employers, but it's going to depend on whether the employer qualifies to even apply for the employee. Remember that when they're applying, they also have to get in touch with the labor department, submit the labor certification. And in that process, they have to show that they qualify as an employer that's able to petition for the employee. And then it also depends on different what visa they're applying for. For example, the H-2B may not be for all employers, because maybe not all employers require seasonal employees. And for the H-2B visa, it's for seasonal employees. So it's going to depend, but I would say the employer can possibly fall into any one of the categories. Any one of the categories. All right, go ahead, put your questions in the comments and I will answer your questions. Uh, can you work with an immigration attorney as a paralegal? So yes, so immigration attorneys do have paralegals. All right. I'm scrolling through. Bear with me as I go through to answer your questions. Okay. Oh, no audio. Okay, let's. All right, let's keep going through. I'm just scrolling through. Thanks so much for the follows. I appreciate it. Okay, my husband filed for me. I won. I'm not sure. Please, if my EAD card is produced and mailed, does this mean my I-130 will be approved? So the work permit is there while you're going through the process, but it doesn't mean that you're going to ultimately be approved for the I-130. That's going to depend on the evidence that you've provided. Quickly, go ahead, put your questions in the comments on Instagram. I had to sign back in, so put your questions in the comments quickly so I can answer. All right, on YouTube, let's see. Is it difficult to win VAWA without police report or restraining order? No, it is not. I mean, there are different types of abuses, mistreatment, and so it's going to though depend on the credibility of the applicant, the detail that's provided, and the evidence. So, regardless of whether a police report or restraining order is included. Um, Now, I have recently even just gotten a VAWA approval based on financial abuse. Now, just my client was financially abused and was able to get the VAWA. So, the police report is not required. My VAWA approved when I get the green card. Oh, congratulations. Now that your VAWA is approved, you'll be moved over to adjustment of status to get the green card. I don't know if you already went through the green card process. My father's son did not file for him while coming to the US. The child is in the US, the father is a citizen, and now what can be done? So he needs to schedule an appointment. I think we had this question before. Um, Now, in this case, he needs to explore whether he can file adjustment of status for the son. As long as they're under 18, under 21, they can qualify for adjustment of status through a citizen, U.S. citizen spouse. If you apply for the VAWA and you did not apply for the work permit, can you reapply for it while your case is pending, or can you do an expedite work permit? So you can apply for the work permit while your process is going through, as long as you applied for adjustment of status. However, that's not a basis to expedite your work permit, because it would be an error on your side and not the USCIS side. So, if you need assistance, always don't hesitate to contact us, and we'll assist. Let's see. Greetings. You get married and your spouse cheated and get pregnant. Can that be grounds for getting your status? Possibly. If, remember that VAWA includes extreme cruelty, which is emotional. And so if a part of that is the spouse was disrespectful, the spouse went out and was, committed this infidelity, and then possibly tried to pass the pregnancy off for yours, then it could possibly qualify you for VAWA. But it really comes down to the facts here, and I'd have to understand exactly what you're going through. What can a person do if he's on J1 that is going to expire in 1 month? Can they apply for another visa? It's possible. It depends. Do you have a 2-year foreign residency requirement? That could allow you to change status. All right. Can you elaborate on financial abuse? So, are they draining you of your money? Are they blackmailing you, saying you have to give them money or else? Those are examples of financial abuse. If you file for a T visa and your kid is in Jamaica, does it take the same time for you and him? If your child is applying along with you, which you have that right, you will when you get approved, your child is going to be approved, and within a month or two, they'll get their visa interview to come to the U.S. Can EAD application be approved even before decision is made on your I-130? Absolutely. Within 3 to 6 months of applying, you should be getting that. That EAD. Can I file for asylum though I'm on a visitor's visa? Absolutely. Yes. Just make sure you don't wait for 365 days to pass. For an F1 who is going through F1 reinstatement, will there be issues during her AOS process through her citizen spouse? She was engaged and got married. So this is complex. It may not, but it depends on what was the basis for losing the F1 status to begin with. Usually with an overstay of an F1, it doesn't, if you're going through a spouse, they don't usually penalize you for an overstay or for, losing your F1 status. But it's going to depend. And now, if you're going through, and since you have a citizen spouse, it shouldn't be held against you. But as usual, you can only give me very limited information, and this is where the consultation is going to be very important. So let me tell you how to get in touch with me. Go to the link in the profile, click on the link. You'll see a button to schedule your own appointment. You'll see the website. You can go to the website, learn more about me, call the number. Staff will be more than happy to assist you. I am going to call it a day, but I am going to work on coming back here at lunchtime again, where I can talk about some more topics, and you can also ask your questions. Thanks so much, everyone, for your time and patience. I appreciate it. I'll be back tomorrow. So if you didn't get the answer to your question today, I'll be back tomorrow to be able to answer more questions. So stay tuned, come join me tomorrow, and keep those questions in mind. So as soon as you come on, you can type your questions in the comments. It's nice to see all of you, and I'll talk to you tomorrow. All right.